I'm announcing the House of Representatives moving forward with an official impeachment inquiry.
The president can attack the whistleblower rhetorically.
Though it's unclear what impeachment charges the U.S. House may level against President Donald Trump, a discussion about what the U.S. Constitution means by high crimes and misdemeanors has already begun.
He's guilty of very serious high crimes and misdemeanors.
Not one of them pointed out a high crime or misdemeanor.
A whistleblower's complaint focuses on a July 25th phone call between Trump and his Ukrainian counterpart, Vladimir Zelensky. The complaint alleges that Trump sought to use the powers of his office to push Ukraine to investigate Democratic rival Joe Biden and his son, and White House officials acted to conceal evidence.
The call was perfect. When the whistleblower reported it, he made it sound terrible.
The debate in Congress is being informed by impeachment proceedings over the past 150 years involving 3 presidents. In each instance, the legislative branch grappled with what the minds behind the Constitution intended with the words high crimes and misdemeanors.
It's obviously a pretty enigmatic phrase.
Law professor Frank Bowman recently published a book on the subject. He says the drafters of the Constitution derived the phrasing from British parliamentary practice.
It doesn't mean what it seems to mean. Because if we read the words high crimes and misdemeanors as modern 21st century Americans, the first thing we think of is, oh, well, there must be an indictable, prosecutable crime involved. And that's plainly not the case.
Bowman says the president committing a crime, in the framers' eyes, was neither necessary nor always sufficient.
I think they had in mind was a tool for the legislature to deal with executive overreach, with executive abuse of power, and in particular, corruption by the president.
President Andrew Johnson was impeached in 1868 after breaking a law, but it didn't ultimately result in his removal from office. After the assassination of President Abraham Lincoln, Johnson assumed leadership of post-Civil War Reconstruction. Johnson favored readmitting Southern states back quickly. The Republican-controlled Congress vehemently objected. When Johnson let former leaders of the Confederacy regain political power, his fellow Republicans were horrified.
The specific reason for which he's impeached was a violation of the Tenure of Office Act that said that the president could not fire a list of appointees, including the Secretary of War, without first getting the consent of the Senate.
Johnson did so anyway, asserting that the Tenure of Office Act was, in his view, unconstitutional.
And as soon as he did it, within days, they filed articles of impeachment because now they had a concrete offense to which they could point.
Johnson escaped conviction in the Senate by a single vote.
Some people would say it was because some members of the Senate were worried about impeaching a president over what some perceived as a policy difference, even a really very profound one.
By resigning from office in 1974, President Richard Nixon ducked almost certain impeachment by the House and conviction by the Senate.
I shall resign the presidency effective at noon tomorrow.
That came after the House Judiciary Committee's investigation into the Watergate scandal. The committee considered the meaning of high crimes and misdemeanors. Nixon's defenders argued that no evidence directly linked Nixon to criminal acts.
We are in effect saying, Mr. Chairman, that a president may be impeached in the future if a Congress expresses no confidence in his conduct.
The House Judiciary Committee ultimately approved 3 articles of impeachment against Nixon: obstruction of justice, abuse of power, and contempt of Congress.
They considered that argument and rejected it and concluded high crimes and misdemeanors is a much broader term, that it involves the kinds of behavior that render a president unfit for office, whether it's criminal or not.
I misled people, including even my wife. I deeply regret that.
During President Bill Clinton's impeachment in 1998, the Republican-controlled House focused on Clinton's alleged crime, obstructing justice, and lying under oath about his sexual affair with Monica Lewinsky.
This is called perjury. The matter before the House is a question of the willful, premeditated, deliberate corruption of the nation's system of justice.
House Democrats, many conceding that Clinton's behavior was reprehensible, argued the punishment of impeachment didn't fit the crime.
We are considering overturning the free choice and vote of over almost 50 million Americans.
On this vote,
The House, voting largely along party lines, impeached Clinton. Before the Senate's trial, legal scholars weighed in on whether Clinton's behavior amounted to what the Constitution's authors meant by high crimes and misdemeanors. The Senate, also controlled by Republicans, failed to muster the 2/3 of members' votes needed to convict and remove Clinton from office.
Alleged abuses by President Clinton do not indicate that he is a danger to the nation.
We don't remove presidents for small matters. I mean, that is, I guess, the lesson of the Clinton impeachment.
Democrats now face the challenge of convincing the public that Trump's alleged abuses of power are no small matter, and also to make the case that the country can't afford to wait until November of 2020 for the voters to decide if Trump should remain in the Oval Office.